Welcome to this video presentation on the mortgage servicing rules. In this video, we will discuss how the rules apply to successors and interest. The rules for successors and interest ensure that when someone receives ownership rights to a property, they are able to work productively with the servicer. The rules also provide certain privacy protections for borrowers and successors in interest. This video discusses rules for prompt response to potential or confirmed successors in interest, and prompt determination and communication of the documentation needed to confirm a potential successor in interest. Once a successor in interest is confirmed, servicers must treat them as they would a borrower. There is no general small servicer exemption from the successor in interest requirements. However, the same rules and exceptions apply with respect to confirmed successors in interest as for other borrowers. Further, under Regulation X, large servicers must have written policies and procedures to facilitate prompt communication with potential and confirmed successors in interest, and to confirm the identity of a successor in interest. We'll start by defining successor in interest. A successor in interest is someone who receives an ownership interest in a property securing an outstanding mortgage loan through inheritance or certain other transfers. Examples include transfer on the death of a joint tenant, transfer to a relative on the death of a borrower, or transfer to a spouse from a divorce. Servicers have certain obligations to potential successors in interest. All servicers must respond to written requests from a person or their agent indicating that a person may be a successor in interest if the request includes the borrower's name from whom the ownership interest was received and information to identify the mortgage loan account. There are time limits to acknowledge written requests from potential successors in interest and provide a written description of the documents the servicer requires to confirm the person's identity and property ownership interest. First, the rules require you to acknowledge receipt of the written request within 5 days, excluding holidays and weekends. Then, within 30 days, excluding holidays and weekends, the rules require you to provide a description of the documents you need to confirm identity and ownership interest. A servicer is not required to conduct a search for potential successors in interest if the servicer has not received actual notice of their existence. The rules apply generally to a successor in interest once a servicer confirms the status of a potential successor in interest by confirming a person's identity and ownership interest in a dwelling or property that secures a mortgage loan. A servicer may not require a person to assume a mortgage loan to be considered a successor in interest. A joint obligor, or person who assumes the mortgage loan obligation, has protections under Regulation X and Regulation Z that are not limited to the protections applicable to a confirmed successor in interest under the rules. Servicers must treat a confirmed successor in interest as a borrower for purposes of the rules under Regulation X, and a consumer for purposes of the rules under Regulation Z. The rules generally apply to confirmed successors in interest in the same way they would apply to another borrower or consumer. If a servicer, such as a small servicer, is otherwise exempt from a requirement, the servicer does not need to comply with that requirement with regard to a confirmed successor in interest. However, there is no general exemption from the successor in interest requirements for small servicers. Next, we will discuss some of the privacy considerations relating to confirmed successors in interest. The rules require you to send information to borrowers or successors in interest about a mortgage loan. Recognizing privacy concerns, the rules authorize servicers to limit the information provided about non-requesting borrower or successor in interest. In responding to requests for information and notices of error, you may omit the non-requester's personal financial, location, and contact information. However, You may never omit information about the mortgage loan terms, status, and payment history. In addition, under the rules, you are not required generally to send a confirmed successor in interest a notice or disclosure if you provide that same notice to another borrower or consumer on the account. For example, if you provide a forced place insurance notice to a borrower or confirmed successor in interest, you don't have to send the same forced place insurance notice to another confirmed successor in interest. A confirmed successor in interest can request copies of servicing notices and other information under the Information Request Rules in Regulation X. Similarly, if you are a large servicer and therefore subject to the early intervention requirements, you are not required to comply with the live contact requirements with respect to a confirmed successor in interest if you are complying with those requirements with respect to another borrower, including another confirmed successor in interest. Some of the model and sample forms in Regulation X and Regulation Z include language that may suggest the recipient of the notice is liable for the mortgage, which could confuse a successor in interest who has not assumed the mortgage loan. One of the ways that the rules address this potential for confusion is by allowing you to send a confirmed successor in interest who has not assumed the mortgage loan an optional written notice and acknowledgement form. This option relieves a servicer of certain notice and early intervention live contact requirements until the confirmed successor in interest either returns the executed form or assumes the mortgage loan obligation under state law. There is no time limit to return an executed acknowledgement. A confirmed successor in interest may later revoke any executed acknowledgement. You can review Regulation X and CFPB resources for details on the content and other requirements for this process and the specific disclosures affected. This concludes our video on successors in interest and the mortgage servicing rules. In this video, we discussed confirming successors in interest and communicating with potential and confirmed successors in interest. We also talked about privacy considerations related to successors in interest, including information the rules allow you to omit from communications with confirmed successors in interest and certain information that you may not leave out. Thank you for watching this video on the mortgage servicing rules. We hope you found it both useful and informative.